Okay. Hello, everyone. Welcome to our webcast today. Good afternoon to those of you joining us in the UK, and good morning to those of you joining us in the US. Really glad to have you here, and we're looking forward to a really engaging and hopefully insightful conversation about US immigration, the challenges, but also the solutions that still exist for UK companies who are either looking to expand operations to the United States or already have operations in the U.S. and are looking to grow those further. So just a couple things before we get into the webcast. Just want to let everyone know that this webcast will be recorded. So if you want to go back and check a slide or listen to it again because you missed something, we will post a recorded version of the webcast after the event. Also, the event will be 60 minutes, and we're going to be respectful of everyone's time and keep this as close to 60 minutes as possible. We are reserving somewhere around a half an hour at the end of the presentation for Q&A, and the Q&A will be, if you have questions, you don't need to wait till the end of the presentation to submit the questions. You can go ahead and submit them as we are talking. If we have the chance to answer it as we go, we'll try to do that. Otherwise, we will curate the questions at the end, and we will answer those questions that you have. If we don't get to everybody's question, please rest assured that we will reach out to you after the webcast and answer your questions. So with that, let's get started. RJ, can you put up the first slide with the speakers, please? Okay. All right. So everyone, just wanted to quickly introduce the speakers today. From Ellis Porter, we have myself. My name is Mark Topolewski. I'm the managing attorney of Ellis Porter, based here in the U.S. in Metro Detroit, Michigan. Also joining us on the call, we have a two-continent call today. Also joining us on the call is my attorney colleague, Arvinder Ubi, who's the director of Ellis Porter UK, based in London. Also joining us from Ellis Porter is my attorney colleague, Anthony Mosco, also here in Detroit, director with Ellis Porter US. And also pleased to have with us today Ashley Stearns, vice counsel from the UK's Department for International Trade, and she is joining us from the Big Apple in New York City. Really excited to be collaborating with the DIT on this webcast, and we hope it brings everyone lots of value. Okay, Arvind, if you can go into the next slide, I'm going to do a quick introduction of Ellis Porter, just to let you know who we are. So Ellis Porter, we are an immigration law firm. All we do is immigration and global mobility. We made a decision a long time ago that immigration is a very complex area of law, and if you want to be an expert in this area, you need to focus on it exclusively. So that's all we do. But within the field of immigration, we consider ourselves a comprehensive immigration firm. So we handle basically every facet of U.S. immigration, global immigration, and global mobility, and we have experts in each of those areas within our firm. We do have over 65 immigration professionals at Ellis Porter. That makes us one of the top 15 largest immigration firms in the United States. Of those 65 immigration professionals, we have over 27 attorneys, again, focused on basically every facet of U.S. immigration law, as well as global visas and global mobility. We're also, what I think is interesting is that we're the second largest U.S. Immigration firm with a UK presence. When we were looking to open our office in the UK, our vendor, my colleague, as he can explain, is actually from the UK. As we were looking to open our office and kind of researching the market, what we found was that although there's a lot of smaller U.S. immigration attorneys that are based in London, not any of them had operations in the United States. And so we thought there was a really unique opportunity for us to set up a base in the UK to help better serve some of our clients in the United States who have operations in the UK as well as throughout Europe, but also to serve clients and individuals and companies in the UK who have a need for U.S. immigration services and like the fact of that they can reach out and meet with someone in person, talk to someone in their own time zone about immigration issues and have boots on the ground, but then have the full force and resources of a large immigration firm based in the U.S. Behind them and supporting them, because everything we file, all the applications we file are all done here in the United States. We do have in the U.S. we have 3 offices based in Metro Detroit, which is kind of now a growing. Clearly, it's the Motor City, and it's an automotive and engineering hub. It's also, interestingly, a growing fintech hub as well. We have 2 of the largest online mortgage companies here, and the fintech space and the tech space is growing here quite a bit. We also have an office in Ann Arbor, which is obviously an education and research center, very well known throughout the United States, and we have an office in Chicago as well, serving a few of our very large research clients. Our UK office is based in London, and that's where our vendor is sitting today. RJ, could you go to the next slide, please? So essentially, as a comprehensive immigration firm, we have the professionals here to handle any kind of immigration case that you might need. But really, we focus. It's not just about filing your case and submitting the application. It's also about helping you with strategy planning and strategy decisions. For your company and your employees. So, just wanted to highlight some of the other things that we do as part of the full scope of our services. But we will work with companies to help them. If you're looking to set up a new office in the United States, we will help you do that and help make sure you have staffed that office with all the key personnel that you need. When you have personnel here, we'll make sure that your company is complying with all the immigration regulatory compliance for your company as well as for your employees. A lot of people don't know that too, that sometimes if you take on, as you make a direct investment or you have a venture capital investment and it changes the ownership structure of your firm, that can have immigration implications too. And as you're growing, those things might happen, and our job is to make sure that we help you navigate any of the immigration implications that result from that, as well as mergers and acquisitions. A lot of times companies are coming here, they're growing, they see merger opportunities to take advantage of. But again, those can also have immigration implications, and we can help you with the strategy of those transactions. And lastly, again, we think of ourselves as an immigration and a global mobility firm. And when you talk about global mobility, it's the immigration part, but it's also global visas. It's also coordinating closely with international tax experts. We work closely with a firm called RSM to deliver a more integrated immigration and international tax solution. We can help with international HR issues. And so we really look at global mobility and immigration as the whole picture, and we can help you in any respect that you need assistance with as you are either moving your operations to the United States or establishing or growing operations that are already here. With that, I want to hand it off to Ashley to describe a little bit about the UK's Department of International Trade and all the wonderful resources that they have available for UK companies who are doing business in the United States. Ashley?
Hello, everyone, and good morning from Brooklyn, and good afternoon to those of you in the UK. As Mark said, I am Ashley Stearns, and I head up all things tech for the British Consulate in New York with the Department for International Trade. A large part of our job is to help UK companies that are looking to do more business in the US. So we help companies that are in that first step as far as just starting to explore what opportunities are there for them in the US market. We then help companies that are looking to sell their services or products in the US. And then hopefully that last portion of expanding and growing to actually setting up a physical location. So just want to thank Ellis Porter again for hosting this webinar. We have a lot of UK companies I know on this call that have a lot of questions about what this current market looks like. Obviously, it's quite confusing from an immigration standpoint, particularly given the restrictions from COVID-19. And our job as DIT is to try to help help companies understand and navigate that market as best as possible with the help of companies and service providers like Ellis Porter. I have a slide up here that kind of shows the exact services that we have on offer for UK companies that are looking to explore, set up, and grow in the US. I won't read out all of these bullets. We help a lot. Each company is very different in what they need as far as their US expansion plans. But just to say that we can certainly help both with colleagues back in the UK called International Trade Advisors that help with some of those first steps, all the way to kind of connecting you into our different offices. We have 9 across the US market, covering all sectors. So whether you are a tech company like the ones that I work with, or a company that works in oil and gas or manufacturing, we can help you with your US growth and expansion plans. So with that, if you have any questions about how DIT can assist your company, please put them in the chat or reach out to us directly. And otherwise, I will hand it back to Ellis Porter to get into what we're all really here for, which is to figure out this mess of immigration in the US. Thank you.
Thanks, Ashley. And again, thank you again for collaborating with us together on this webcast. Again, lots of very timely issues to talk about, and real quick, for all the UK companies on board who aren't familiar with the DIT and their services, again, it has been amazing for us to learn just how much support services they have available to you, and their goal really is to help you succeed. So I urge you to reach out to them and take advantage of all the great connections and support that they offer. So with that, we're going to dive into the immigration section. As Ashley says, is what we're here to talk about. And I guess the one thing I wanted to say before we get started is that, obviously, there are a lot of challenges right now in immigration. We've divided up the talk here. First, we're going to talk about when companies are looking to come to the U.S., or if a UK company or has operations here and wants to expand their operations in the U.S., we're going to talk about the basic options, the U.S. immigration options that they have available to them to do that. And we're going to go through those kind of quickly. But obviously, with the pandemic, there's now a lot of, and those processes were always, had their own unique challenges. But now with the pandemic, there's new challenges to even executing strategies using those options. And so after we talk about the basic options available to most UK companies looking to do business in the US, Anthony, our vendor, are also going to talk about what some of the challenges are because of the pandemic and what kind of issues that's created. But I think more importantly, talking about what are some of the available solutions to that. And I think if there's one thing that we can stress that we want you to take away from this is that, yes, absolutely, there are some new challenges in the immigration environment in the United States right now. There's no doubt about that. However, there are still a lot of avenues available. There's a lot of visa categories that have not been impacted by this. There's a lot of ways to request exemptions for certain bans or suspensions. So I guess the key to, if you had plans or you have plans to expand your business, don't give up those plans. There are still ways to make that happen. It might take a little bit of extra planning. It might take a little bit of extra time, but there's still, the U.S. is still open for business, and there are still immigration options to get you here to do what you need to do to expand and grow your business. So with that, we're going to talk again really quickly about normally what are the options that a UK company would be looking at when they're talking about US immigration and doing business in the US. So the first, probably the most common visa, is the B1 visa, or the business visitor. So this would be for any UK professional who wants to come to the United States for a business meeting or for a sales meeting or for a conference, anything that's not working in the United States. And this is this category continues to exist and continues to be used. Anthony's and our vendor are going to talk about some challenges that exist, but individuals are still able to come to the U.S. On these business visits and do these things. RJ, can you go to the next slide, please? Probably the biggest issue, though, that we've always seen historically with B1 visas is, again, there is a list of what you can do. There's certain activities that are permitted, but there's certain activities that aren't. And again, the activities that aren't permitted would be, again, what the U.S. Immigration Service would consider working in the United States or working, doing any activity that would normally require work authorization or getting paid from a U.S. source. The issue is as we know in the current state of how business works, it's really hard to say. It's kind of a gray area. When does a meeting become work, and when does a business visit become work? It's really hard to know. And a lot of times, what the Immigration Service is going to look at is they're going to look at the activity, but they're also going to look at how frequently are you trying to come to the U.S. on a B-1 visa, and how long do you stay when you come, and they kind of weigh those factors. So it's not really a perfect science. But the key is that when you come is to make sure that you are coming for one of these acceptable activities and that you are not coming to work. And when they ask you what you're doing, we always tell our clients, don't say the word work. It can get you in trouble. Now, the B1 is business visitor visa is an immigration category. Some people can come and apply and get a B1 business visitor visa at a consulate, but citizens of certain countries, the visa waiver countries, can actually be admitted in B1 status for up to 90 days without having to get a visa at the U.S. consulate. They can actually just register with the ESTA system online, and then they can use that to come into the United States for a period of up to 90 days. Key things to remember there is that the only limitation of using ESTA to come into the United States is you can't extend your stay any longer than the 90 days, and then you're not allowed to change your status to something else once you're here. Next slide, RJ. Probably the most common category for individuals who are doing business in the United States is the L1 intercompany transfer visa. This is for companies who have an office in the UK but also have an office in the US. It can also be used to establish a new office. That's called a new office L1, or it can be used for companies that have existing offices in both locations. The L1 category allows you to transfer executives and managers to the US under the L1A category, as well as specialized knowledge or technicians who have kind of special proprietary knowledge of your company's products or services. They can be transferred to the U.S. for up to 5 years in L1B and L1B status. It's also important to note that the L2 spouses are able to get work authorization in the L1 category. Now with that, I'm going to now hand it over to our vendor to talk about another visa category that's commonly used, the E2, as well as some other ones that are used a little bit less frequently but can be strategically important. And then he's going to jump into what some of the restrictions are and how they work. So our vendor, with that, take it away.
Thanks, Mark. So let's explore the E1 and E2 visa options. The E2 is probably one of the most commonly used visa types for UK companies looking to expand into the US. And the E1 is probably one of the most underutilized visa types for that purpose. Both are based on a respective country having a treaty of trade with the US. And for UK companies utilizing an e-visa, anyone using them will need to also have a UK citizenship as well. Now, the E2 is based on a UK company making a substantial investment into a US company. And there's no magic number that's required. So we've seen some cases be approved for as little as a $20,000 investment, but I'd have to say that these are incredibly rare. They do require an incredibly robust and well-documented business plan to get those smaller investment amounts approved, but nonetheless, the scope is quite broad with those. The investment amount is really documented on how much of an investment would it require to get the company to become a viable business in the US, and that's what embassies are looking for with E2s. Now, the E1 isn't based on a substantial investment, but rather showing substantial trade with the US. And now the reason I say that it's underutilized is because many people think that the E1 can only be utilized for the trade of goods. However, the regulations allow the trade of services as well. And so we've seen E1s get approved for companies that are in financial services, IT, insurance, and property as well. So again, the E1 is very broad. Don't write it out because you may not be trading goods. It has a large scope that can be utilized with it. Both e-visas, you can transfer managers and executives, as well as essentially skilled employees. You can apply for the e-visa directly at the US Embassy in London, so you can avoid some government filing fees through filing with USCIS. And unlike the L1, your employees don't need to be employed for a full year prior to applying for any of the e-visas. Okay, next slide. We're going to discuss some of the other visa categories that are available. Now, the H1B is probably the most well-known visa category out there, but it's typically used by companies who already have an established presence in the US. The reason for that is there is a numerical limit on the number of H1Bs that are issued each year, and there's also a lottery that takes place every April. And the selection rate bounces around the high 30%, so it's not incredibly a viable option all the time. Now, one visa category that I think is tremendous for O1 is the O1s, which is intended for those who have extraordinary ability. It's a great visa option for entrepreneurs and business owners. Typically, this is used for researchers and scientists, but well-documented entrepreneurs and business owners can definitely benefit from an O1 as well. The benefits of an O1 are there's no investment requirement, you can sponsor yourself in some cases, and there's no prevailing wage requirements either. In terms of documentation required to meet the O1 criteria, we may rely on national or international awards, testaments from other leading experts in the field, publications, press coverage, presentations. We can use sales numbers. We can even utilize being awarded substantial VC investments through winning pitch events as well. So again, the O1, you may see it referred to as for researchers and scientists, but it has some great use for entrepreneurs and business owners as well. Next slide. Next, we're going to kind of move into the longer term options, which are referred to as green cards in the US. Now, most of the time, these are typically applied for when an individual has been in the US in one of the non-immigrant statuses that Mark and I briefly discussed. However, there are some situations where individuals will apply for a green card prior to going into the US for the first time. In some situations, the processing time may be a little bit shorter. There are multiple options, but I really want to focus on the EB1 category and the EB2 national interest waivers for the purposes of this presentation today. Both are great options for entrepreneurs and business owners as well. And I think the EB1 is typically based on an individual who has extraordinary ability. The EB2 national interest waiver is there for somebody who has exceptional ability, which is less than extraordinary, but their presence in the US is going to be of national interest. These, again, are typically used for researchers and scientists, but we've recently had some great success for entrepreneurs and business owners. So they shouldn't be discounted if you're looking at options to either move to the US for the first time, or if you're planning to stay in the US for a little bit longer than you had initially thought, and you wanted to obtain a green card and get the benefits of having a green card as well. So next slide. We're also going to now talk about, we've dealt with the non-immigrant visas and some of the immigrant visas. We're going to talk about some of the travel limitations and the solutions around those. So as you're probably all aware, there is currently a travel ban in place for several travel ban countries, and they are China, Iran, Brazil, the UK and Ireland, and also the Schengen area. Now, this prohibits entry into the US if you've been in one of these countries within the prior 14 days prior to entry into the US. So we're gonna, although this is in place, we really want to focus on the solution. So in the next slide, we're gonna discuss some of the solutions that we have. Archie, can we go to the next slide? So as I was saying, despite the limitations right now, there's two strategies that we're looking at. One of those is if you've been in one of these countries and you're trying to enter the US, you can travel to a non-travel banned country for 14 days and then travel into the US. You can also apply for what's called a national interest exception with a local US embassy. Now, you would have to show that the travel will have a significant economic and public health benefit to the US. And an example of how this works, a couple of weeks ago, I was contacted by a client who needed to get into the US on their ESTA. We were able to submit a national interest exception. The client sold machinery to a US company. They needed to go into the US to advise on the installation of their equipment. From the day that they contacted me, on day 6, the client was in Texas with their specific clients. And so I bring that example up just to show you the speed at which the US Embassy in London is working with some of these national interest exceptions. So despite these limitations, there are solutions, and to their credit, the US Embassy in London specifically is working very, very quickly on these cases. So they're the travel limitations. I'm going to hand it over to my colleague Anthony, who's going to discuss some of the visa limitations and the solutions that we've created and we've discussed internally to get around some of those visa issues. So over to you, Anthony.
Thank you, Arvinder. The first topic that I do want to discuss is in regard to the immigrant visa suspension. So Arvinder addressed a little bit about green cards, individuals living permanently in the U.S. The immigrant visa is basically issued by the U.S. consulate to give an individual the ability to travel to the U.S. and to live permanently. On April 22nd, the president basically issued a suspension on immigrant visas, and the rationale behind this was basically to curb the influx of foreign national long-term employment into the U.S. That was the presumed purpose. I do want to mention that the immigrant visa ban only suspends new visas. It doesn't impact individuals who already had visas at the time that the suspension was handed down on April 22nd. It also, of course, doesn't impact individuals applying for green cards within the U.S. There are certain exemptions in the national interest for these immigrant visa bans. Individuals coming over applying for an immigrant visa to support the healthcare field. You have your EB-5 investors, spouses or minor children of U.S. citizens, certain law enforcement military exceptions, and those in danger of reaching a qualifying aging out category. There actually is federal litigation on this, where the federal courts have ruled that the president has limited powers for barring this, but as of now, it runs through the end of 2020. RJ? And then there also was issued on June 22nd the non-immigrant visa ban, which came out, about 2 months after the immigrant visa ban. But again, the purpose of this was to curb foreign national employees from coming to the U.S. Primarily, the banned categories were, your H's, your L's. The suspension does not impact individuals coming over in the treaty trader categories. Does not impact O1s that Arvinder discussed previously. It also doesn't impact visa renewals, so people coming to continue ongoing employment. Also, oddly, the ban doesn't impact processing at the port of entry. So for Canadians seeking work authorized status, they are not impacted either. So they're still able to apply for H's and L's and essentially any other work authorized visa that's processed at a U.S.-Canada port of entry. Next slide. There are national interest exemptions that are issued for the L1A, so the multinational manager intracompany transfer visa that Arvinder had discussed. The Department of State more specifically outlined the qualifying exemptions rather recently. These exemptions are, again, in the national interest, individuals serving the public health, the U.S. government agency support, and then also individuals who serve, critical business needs and critical infrastructures in IT, transportation, again, health, food and agriculture, etc. Within the critical business needs subcategory, the government is looking for, individuals, L1As, who would provide strategic level direction to the company. They'll operate at a senior level, and they currently have extensive experience within the company. And next slide. Similarly, for the national interest exemptions for the L1B specialized knowledge individuals, the exemption is pretty similar to the exemptions for the L1A multinational managers, except the criteria for the business need. The business need criteria for the national interest exemption for the L1B is it overlaps significantly with just the general visa requirements for the L1B, you know, establishing that you have specialized knowledge in a company process and that you would provide substantial benefit that basically few within the company can. The method for applying for these national interest exemptions for the L1s, it differs by consulate. Some consulates, they won't even allow you to schedule an interview until you provide them in advance evidence of your national interest exemption eligibility, whereas other consulates will say, you know, we expect you to basically to make your case for the national interest exemption when you show up at the consulate. It's a bit easier, as we found, for the L1As, because the L1A requirements are a bit more cut and dried, a bit more black and white, as opposed to the more abstract L1B exemptions that we're seeing. And then also we're finding that the consulates are issuing sort of blanket exemptions. So if you're getting the exemption of the temporary non-immigrant visa ban, they're also granting exemptions for the travel ban that Arvinder had mentioned, assuming that you are coming from one of those banned countries. Next slide, RJ. Really, the biggest issue that we are seeing, the biggest logistical issue, is just the consulate closures. You're not able to apply for an exemption if the consulate's not open to accept. Some consulates are more transparent and accommodating than others. The consulates in Europe typically are more accommodating than those in South Asia. Now with London, right now they're indicating for most visa categories no available appointments until August of 2021. But essentially what individuals have to do, they have to book the soonest appointment, and then after that request an emergency accommodation for an interview, and then basically at that point they can make their case for the national interest exemption. I'm now going to pass it along to Ashley. I think we have some questions that we received.
Hey Anthony, real quick before you take over, Ashley, Anthony, can you just speak, because I know we've had a couple cases recently where we were able to successfully get some exemptions. Can you talk a little bit about, just give a little bit of background about what kind of cases those were and what were the factors that we were able to use successfully in making that argument to the consulate?
So it's differed by some of the consulates. I mean, they have their own requirements. Primarily, we've been able
London specific.
Right. So specific to London, we were able to get exemptions for senior level executives and senior level managers. The process is a little unclear, however. What the individual basically had to do was schedule the earliest appointment that they could find. Then we had to submit documentation to the consulate in advance arguing the individual's eligibility for the exception. And then basically out of the blue, the consulate emailed us and said, your appointment's in 5 days. So we very much had to make sure that the individual was prepared. He was a CFO coming to support a U.S. company that was involved in the food supply chain. But once the consulate was able to see documentation from the company as to the strategic level direction he would be providing in support of the U.S. company, the critical business infrastructure they would be serving, they were rather quickly issued the L1 visa thereafter.
All right, thanks. Yes, so Ashley, if you want to go ahead, I know it looks like we have some questions that have been posted. If you want to go ahead and moderate that for us, we're happy to answer them. Some really good questions.
Yeah, absolutely, and please keep them coming, everyone. We have some really good ones. I think if we could go ahead and kick off on kind of a more general question about just the types, and you kind of touched on this earlier, but just the types of delays on the visa processing for new visas. So for companies that might be thinking about expanding potentially in 2021, like what does that timeline need to look like and able to account for those delays, if we could expand on that. And then also, I guess to tie into that question about delays in processing or even potential refusals of L1 extensions for people that already have a visa. So both the new and existing.
Okay, well, I'll jump in quickly and then to just speak to some processing times in the U.S. and then I'm going to have Anthony talk to on processing times we're seeing at the consulates as far as getting the visas, as well as what we're seeing as far as an increase in denial rates for L1s, L1As, and L1Bs but how we're able to still get approvals in those categories. But generally speaking, so keep in mind some immigration cases can be filed directly at a consulate outside the U.S. in London. Other cases have to be filed with U.S. Citizenship and Immigration Services, or USCIS, in the U.S. first and get an approval notice, and then you can go get the visa in London. And when we're talking about U.S. CIS processing times, those processing times have definitely slowed under the Trump administration for a number of different reasons. They've kind of shifted their priority to more enforcement and left less resources for adjudication. They're also re-adjudicating cases, and they got rid of a policy called kind of where they would defer to, if you had an approval before and nothing has changed, they would approve your case again unless something major was different. But now they're re-adjudicating every case as if it's a new case, which is also delaying things. And then adding to that, the Immigration Service here in the U.S. is having some budgetary issues, and they had been hinting that they thought they were going to have to furlough up to 70% of their staff at the end of August if they didn't get additional funding from Congress. Now, within a couple of days before that happened, they said they found a way to avoid that, but they're still indicating that they have severe financial issues, and those financial issues are going to cause delays. So on the U.S. side, any application that's going to require filing something with USCIS first, I guess all I can say is expect delays in those process, and probably a couple of months more than it would normally take. Anthony, can you speak to what we're seeing as far as delays in things like getting appointments and cases that are actually processed, visa applications getting processed by the consulate, and then also can you speak to Ashley's questions about what we're seeing as far as L1 adjudications with USCIS?
Yeah. Okay. Yeah. Thank you. So. Right now, I mean, it depends on the consulate. The biggest issue for a lot of the U.S. consulates is the limited services that they're currently providing to the public. As a matter of public health, they basically shut down a lot of the routine visa services. A lot of times, if we're just able to get, maybe an emergency interview or get an interview in some capacity, for the most part, we've been able to be successful arguing for a national interest exemption. The issue, as we see with the consulate in London, is they're saying, look, we don't have any visa availability for most work authorized visa categories. You're going to have to wait until operations open up or resume or whatever the case may be, which could be sometime next year. And even so, once operations resume, we're going to have to expect an additional backlog of visa appointment availability by maybe 5 to 6 months, even after the consulates reopen. They are still accepting, one reason is they are still accepting, e-registration packets. So once the officers get back and they're behind their desk, they're going to have to catch up on a lot of the paperwork that's there and then start scheduling appointments. But primarily, those are the main issues that we're seeing as far as delays in appointment availability at the consulates. Once they are able to appear at the consulate, make the application for the visa, processing time is a little delayed with them actually getting the visa. It used to take about 7 to 10 days. Now it's taking maybe 2 to 3 weeks, which is likely due in part to them working with a very minimal staff as far as reviewing these visa applications and processing these in a very timely manner. One major challenge that we're seeing with just the general limited availability of the consulates is individuals who are already here. Individuals who are in valid work authorized status. Normally, it's quicker for them to just go to a consulate, for example, on an L1 and renew their visa. Now they're having to file in-country extensions, which are a headache in and of themselves, because USCIS, what Mark had discussed, which is sort of the domestic body for processing immigration benefits, is much more strict when it comes to in-country extensions on E's, in-country extensions on L's, and sometimes you'll see a denial on an extension, even though no facts have changed from the initial granting. So we always have to prepare our clients that, we're going to have to provide every piece of viable evidence that we can to maintain your work authorized status and keep you in status. We used to have that benefit of the consulate, but no longer. But now, it's going to be a challenge now with basically seeking USCIS's help exclusively for immigration benefits.
And whilst we're just talking about visas, I think one consideration for companies or individuals that are currently in the US as we kind of really steamroll ahead towards the end of the year, a lot of individuals will look to travel back home for the holidays. So it's really important, I think, if you're in the US, check when your visa expires, because with the delays we're seeing, especially in the US Embassy in London, you may not be able to get a visa to get back into the US in an appropriately quick manner. So as the holidays approach and the holiday season kind of creeps up on us, just bear that in mind.
So I think that bridges into a question that just came up actually, as far as if you, hold on, there's so many questions, which is great. But if you are already in the US and you would like to go to the UK and come back, are they able to re-enter the US without an NIE?
Our vendor, I'll let you take that one.
Yeah, so again, if you enter into the US, UK, or any of the travel ban countries, you wouldn't be able to travel back into the US unless you either obtain an exception or you travel to a non-travel banned country prior to entering. So even if an exception or exemption is issued, they're typically issued for a one-time only, and it must be used within 30 days. So if you've obtained an exemption, it doesn't mean that you can just come in and out of the US as you like. It's only used for one time, and if you come back into the UK, then that travel ban is going to kick in again.
Thank you. And then that also bridges in nicely with this question as far as, do you have any sort of travel bridges that might exist between New York and London or other states? So if a person, I guess, potentially would fly into a country and wait there for 14 days, it doesn't have a travel ban into the US, would that be possible?
Yeah, I'm going to let Anthony speak to that, because I know we've been using that option and offering that option to a few clients as far as, Mexico, maybe the Caribbean, and the option can work, but there are certainly some things that you have to keep in mind. So Anthony, can you speak to that strategy of going to the third country first, quarantining for 14 days, and then entering to the US?
Right. In most visa categories, coming from particularly the United Kingdom, are subject to this travel ban. Now, there are some intermediary countries that they can visit to remain for 14 days before traveling to the US. We've had clients coming from the UK who were successful going into Antigua, going into Mexico. We had some even fly to Japan and remain for 2 weeks before, which is rather roundabout. Fly to Japan, remain for 2 weeks, and then fly into the US. No issues have been reported. We do advise, though it says 14 days, we say maybe make it 15, just so there's no equivocating from the customs officer as they're seeking and evaluating an individual's admission to the US to make sure that they fulfill those requirements. But a couple things that you're going to want to take into consideration when looking at a country that you may want to make a 14-day stop in is, one, are they accepting visitors? Because some countries, particularly in the Caribbean, sort of shut down a lot of non-essential travel. So unless you're a resident or you have a work visa or you're a citizen of one of those, for example, countries in the Caribbean, they may not let you in. So you want to make sure that they're accepting individuals, for example, from the UK. And another thing is that you want to make sure that there is actually a direct flight from that intermediary country to the US, because if you have to transit through a country that is on the banned list, then you've essentially done yourself no good. So you want to make sure that if you are going to stop for 14, 15 days in one of those intermediary countries, you are able to catch a direct flight to the US. But again, we do advise that an individual, just to be safe, that they do remain for maybe 15 days in that intermediary country.
So I think that probably, Dominic, that likely answers your question that you just published about traveling back from the UK into the US to pick up your belongings. Going to have to take a little bit of an extended holiday somewhere before you can do that. So we have several questions regarding the exemption process that have come up. The first one being, do you think that a company could try to navigate the exemption process by themselves, or do you think they would need to budget to have legal advice to help through the process?
I'll start with that, and then I'll have Anthony speak to the process itself. But I would say, again, we're biased, obviously, but this is new ground for all of us. These exemptions, like Anthony said, the Department of State actually, even though the visa suspension, the travel suspension was issued in many months ago, it wasn't until a couple of weeks ago that the Department of State even came out with some guidance, and even the guidance itself is kind of vague on some points. And so it's been a real process to kind of learn how each consulate is handling this, what factors they think are important, what factors they don't think are important. And in most cases, it ends up almost as if you're submitting an application, because you have to make the same kind of legal arguments that you meet the certain criteria, and you have to provide supporting evidence that's persuasive to show that you meet the criteria, almost in the form of a legal brief. So there's a lot that goes into making that argument. And I think the other part of having the benefit of guidance is that a lot of the hiccups right now we're seeing is just on the practical side of things, just understanding how the consulate's accepting the request, how they're handling it, how they're processing it. And again, we're learning that every day by working with a number of people on these kind of issues. And so I think it can be challenging if you're doing it on your own. That said, I think and Anthony, tell me if I'm wrong, but I would think if you only have to apply for an exemption for the travel, that's a little bit easier than if you have to apply for it on the visa. But I would say, generally, like everything else, I think it's, it could be done, but you just may find that it's going to take you longer, and you're going to probably run into some hurdles that we've already figured out how to got over if you are, doing it on your own. And again, it's such a new process, and we're learning as we go. But as far as the process itself, Anthony, what else would you add to that?
Yeah, I would agree with that. I mean, of course, I am biased in that respect, but when the exemptions were initially handed down, they were so vague, and really, I mean, the Department of State themselves didn't know how to handle or treat how adjudicating some of these exemption requests. And in addition, I mean, particularly if you have attorneys who have handled the process before, maybe they know the direct contacts that they can get in touch with. Sometimes when we submit these national interest exemption requests, you'll get automatic responses with a lot of jargon that may be completely unfamiliar to you. But considering we've been navigating the non-immigrant visa process for many years, we may be able be better positioned to understand a lot of that. And then also there have been occasions where we've had to enlist, some support from a congressional liaison. Our office, we have a lot of outside contacts. We're able to get assistance from certain government officials who may be able to step in and even advocate on behalf of the foreign national who's seeking a national interest exemption. So yeah, I mean, though it's not impossible to handle something like this on your own, but there is a lot of, as Mark said, overlap with arguing just the basic eligibility requirements for the visa itself, and then and the consulates at times can be a little unaccommodating, and I do think in that respect, attorney assistance would be key.
And I would just add, in closing on that also that we've structured our services like we do most all of our services, that we're offering assistance with exemptions on a flat fee basis. So if you are looking for assistance, we're able to say, okay, here's a flat fee cost, so you have predictability on what what the investment would be to get you the help for that process. So if you are interested in that, feel free to reach out. Ashley?
Yeah, so I kind of want to wrap up on the exemption process just because we have a couple other general questions, but just quickly on this, is recruitment considered an exemption for a UK company that would want to hire US individuals?
Arvinder, why don't you take that one?
Sure, absolutely. So again, going in, you have to demonstrate that your travel into the US is going to be for either public health or significant economic benefit. So if you can demonstrate that through hiring, if you're going to go to the US to create additional jobs when there is a high unemployment, that could be a great argument to make. It's all discretionary when it comes down to the officer reviewing the case. So again, presenting the best argument possible, maybe supplementing that with the number of individuals you're going to be hiring. What role are they going to play? How many jobs will this potentially create in that particular area, and how's it going to benefit the economy as a whole? And if you can make that argument and it's succinct, I think that would be a good grounds in which to apply for one of the exemptions.
And then our vendor, would they need to have that evidence in advance, or would you make that case at the appointment at the embassy in London?
I would have that evidence all in hand. As Anthony said, and as we've seen, especially with the US Embassy in London, requesting these appointments, they can come very quickly. And so if you're able to get an appointment within a matter of days, you have to be prepared and have all your documents ready to be able to present, and be ready to present a strong argument if you're going for an in-person interview, because it's a daunting process. And that it goes back to the previous question, whether having an attorney is helpful. In those situations, if you're trying to get into the US for a specific reason to benefit your company, you're not going to go to Disneyland, but certainly it's important to understand exactly what you should be doing, what you can do, what documents to take, what questions you may be asked, and the experience you may have. So the more prepared you are, the better chance of success you'll have.
And so I said I was going to wrap up on this, but this was actually quite a good question. As people decide that they want hopefully to go back to the UK for the holidays, do you think that everyone will have to acquire an exemption to come back into the US, or do you think they're going to have to spend their holidays in Mexico?
I was going to I was going to say real quick, and you can supplement this, our vendor, but yeah, I mean, if we're talking about the year-end holidays, the Christmas holiday, the key factor here is, remember, these exemptions, the visa exemptions, are in place through the end of the year. The travel exemptions actually don't have an end date on it, so it's really hard to know if they're still going to be in place by the end of the year. I think, but the other key factor that we can't lose sight of is that between now and the holidays in the United States, we're going to have an election. And whoever wins that election is probably going to have a huge impact on the direction of immigration policy, whether we continue down a path of becoming more restrictive, or going back to where we were and being a less restrictive and open country. So I think when we're talking about holiday, and we keep saying around the office, like it's hard to plan any strategy more than a couple weeks ahead with all the changes that are going on in immigration. But definitely, for us, it's there's pre-election planning, and then there's going to be post-election planning. And so I think when you're talking about holidays, it's all going to these restrictions very much could still be in place by that point, and they could get extended. And in that case, then we're talking about all those same issues in December and January. Or again, maybe if Biden were to win the election and immigration becomes less restrictive, maybe some of these restrictions go away. And it's also going to be dictated too by the pandemic as well, and what the numbers look like and all that. So it's really hard to say, because I think it's going to depend on the election, and it's going to depend on the current status of the pandemic to know if these things are still in place then or not. If they are, then yes, we're going to be talking about the same things, but we're all hoping that maybe they're not.
Thank you. Okay, so I think I'm going to then jump into some questions that are a little bit more general, but this is kind of a good transition. As far as I know that some of the requirements have changed for the visas. So Laura has asked about what happens if you need to go to the US to take pictures of the office space is required for some visas, and sign a lease and purchase equipment. How has that changed, if at all, under the current environment?
Our vendor, why don't you take that one?
Sure, absolutely. So those are all great examples of utilizing either your ESTA or a B1 visa to go into the US to do those exact jobs. That's what it was intended for. And so again, we go back to, if you have your ESTA or you have a B1 visa, then traveling into the US, you just need to be mindful of that travel ban and requesting that. And again, making that argument, if you need to get your national interest exception, make that argument as to why you need to go into the US, demonstrate how this could potentially create jobs, how you're going to support the recovery of the US economy, and be prepared with information, understand exactly how long you're going to go there, where are you going to stay, when are you going to come back to the UK, what meetings do you have all of those documentation to hand, and be prepared to explain that.
Thank you. So next one is about how easy is it to switch to a different visa? So this person is currently on an O visa, but is curious as to whether or not switching to an L would be a good decision.
Anthony, why don't you take that one?
Sure. So, I mean, I'm assuming that this person might be presently in the U.S. So if they're in O1 status, you know, the current bans do not have any impact on anything that's processed domestically. So assuming the individual meets the eligibility requirements for an L1, if they're moving from an O1 to L1, the present climate hasn't really impacted that. The only thing to keep in mind is with the increased processing times as a result of the pandemic with USCIS, the L1 sponsor may want to consider certain concessions to expedite that L1 petition to ensure that the employer gets a prompt feedback as to the success or not lack of success on that L1 petition. Otherwise, I mean, if we're talking about processing abroad, I mean, at the moment right now, I mean, they would have to go through the current channels as far as getting exemptions, securing an interview, providing the necessary evidence to qualify for a visa and the national interest exception. So there are further challenges at the consulate, but within CIS, I mean, it's the normal challenges prior to the pandemic.
And I would just add to that like Anthony said, a change of status can all be accomplished from within the United States. It's not impacted by any of these visa restrictions or travel restrictions. But keep in mind that certain kinds of changes of visa status in the U.S. You may not get the new work authorization. Like, again, if you were switching from an O1 to an L1, you wouldn't get the new authorization until that L1 was approved. And so, you could file, normal processing, that case could take several months. With premium processing or expedited processing, maybe you can get an answer in 2 to 3 weeks, but you have to take that into consideration as well. And then I think just in this specific case, you have to make sure that you're actually eligible, for L1, the L1 category. And again, as we talked, you have to show that you are going to be sponsored by a company for whom you worked outside the U.S. for that company for at least a year in either an executive or a specialized knowledge capacity.
So I know we're running very close to time, but I think because you mentioned that this one's underutilized, I definitely wanted to get to this question about expanding on the concept of existing trade for E1 visas. So how does someone prove that they qualify for an E1 visa?
Arvinder, why don't you take a stab at that one?
Yeah, absolutely. So again, it's all document related. So pulling up all of your previous sales, extensive documentation, creating a business plan, and sometimes there are several companies out there that will work with you to develop really strong business plans for this purpose, and they'll help you develop and create that documentation. But it is extensive. You may need to go back a year or two to create that and show that you have that substantial trade with the US. And so understanding, being able to collate that information. So if you're in the process and you think that an E1 may be a good option for you in the future, talking with an attorney about how you create that argument, how you create that application at the outset is going to be really important to you being able to collect and collate that information that's going to be necessary maybe 6, 8, 12 months down the road. And you'll have a nice package ready for the attorneys to work with you on, and maybe even a business plan in place to help support your E1 application.
Thank you. And then one I know we're right at 11, but one last question. I think if we can give a really short answer to this one, if someone is looking at sending over someone at mid-2021, when would they have to start their process of getting that person a visa, just in general?
Yeah, I think the earlier the better. I mean, if you already have a person identified now, it is not too early to start talking about what visa strategies are available. Because again, we may be looking at a non-immigrant visa that's going to require USCIS processing, and we're going to need to take into account the possible delays there, and then also once that's approved, delays in getting them the visa. we may be able to look at bringing them directly in on an immigrant visa. Sometimes that's actually an option that can be more that can be faster than a non-immigrant visa. So, but I would say we are now. Every day we're working on cases with clients who are looking to bring people in mid 2021, the end of 2021, and it is absolutely not too early to be having those conversations and actually even getting started on some of these applications as well. So never too early, especially in this current environment.
So I think that's a great way for us to wrap up that conversation. If you're looking at coming over to the U.S. In 2021, please start now. The earlier the better. So yeah, I guess I just want to give a quick thank you to everyone that joined us today. Hopefully you found this useful. We had several questions that we were unfortunately unable to answer, but like Mark said at the beginning, for those of you that did ask questions, please get in touch with them or they will get in touch with you, depending on if you ask the question as an anonymous user or not. But they will try best as possible to answer the remaining questions that we were unable to talk about today. But again, want to thank Ellis Porter so much for giving us their time and giving us this really useful information about how to navigate the current immigration environment in the U.S. And as always, we are here to help you through that process. And there is our contact information for those of you that would like to discuss this further.
Thanks, thanks, Ashley. Thanks, Ashley. Again, thanks to you and all your colleagues at the Department for International Trade. Really appreciated the opportunity to collaborate with you on this, and looking forward to continuing with future collaborations that could be valuable to your client base as well. As I said, I think the two things to keep in mind here is when you're talking about doing business in another country, and we speak from experience here, because like I said, we opened up our office in the UK a year ago. So when we're talking to companies who are have an office across the pond or looking to open an office across the pond, we understand how that can seem intimidating, and on all the logistical challenges and other technical challenges that go into that. And now adding to that, there's these immigration challenges that have arisen as well. But I guess all I can say is that I think as far as the getting your business set up and trying to find your market in the U.S. and being successful in the U.S., those challenges are not insurmountable, because you have people like Ashley and her colleagues at the DIT to help you navigate that. They've seen the issues that you're looking at, and they have come up with ways to help you overcome those hurdles and find success. And the same goes with immigration. There's, again, when you read the newspaper, you read the news, it just sounds like there's just so many challenges right now in immigration that it's just impossible to come to the United States. And that's also not true. And despite those challenges, again, they are not insurmountable as long as you have the right people working with you to guide you along in that process. And again, we're happy to help anybody. If you have questions after this event, feel free to reach out. And as Ashley said, we will also put together a digest of answers to all the questions that we didn't get to answer, and we'll send that out to everybody so you can benefit from that. So once again, thank you all for joining us for this webcast. We could talk for hours on this, and there's probably going to be new news tomorrow. So continue to watch DIT's social media, our social media. We'll keep everybody updated on the latest happenings. But again, thank you for joining us, and have a good rest of the day.
Thanks, Mark.